Good morning, Counsel.
Good morning, Your Honors. May it please the Court. My name is Joe Hanafi. I represent Loster-Andre Bell on a consolidated appeal arising from convictions for felony murder, armed home invasion, arson, and 2 counts of violation of restraining orders. I would begin by saying that under the direction of Commonwealth versus Gunter, there are 4 opportunities to prosecute felony murder to avoid application of the merger doctrine.
Can I just ask you a factual question? And I don't want to interrupt your flow, but were the charges whichever ones were null pros, and I think there were 2 of them, correct?
2 were null pros.
When were they null pros? My question is
They
when?
were, it was announced on the first day of trial, jury selection day, that April 27th, that they were going to be null pros or dismissed, and then ultimately they were on January of 2009 after trial had concluded, but the issues were never given to the jury. Getting back to my argument, there are 4 opportunities to avoid application of the merger doctrine. The first would be clearly to offer or to present numerous indictments or counts alleging specific instances of independent conduct that would support the predicate felony.
But you don't have to indict for it.
You do not. It's one way to approach it. The second approach would be to prosecute on all 3 theories of first-degree murder, premeditated extreme cruelty or atrocity, and felony murder, which in both of those instances the Commonwealth did in the Bell case. The third way is to do it by obtaining or providing or obtaining specific questions answered by the jury, specifically asking them to find independent conduct to support the predicate felony. The fourth way is to have the judge instruct on felony murder, compelling the jury to consider and to focus on an independent ground to support the predicate felony.
What about Larry Key's testimony that he saw the defendant assault Julie Neves and Tiffany Cruz?
Well, which is what I had intended to get to, but Your Honor, in fact, Larry Keyes was one alleged victim, and his testimony.
And the jury acquitted the defendant on the charges involving Larry Keyes, but that doesn't mean they disbelieved all his testimony.
But the Julie Nieves assault or alleged assault was one of the cases that was dismissed, so that the jury was never asked, and I submit never wrestled.
Dismissed or null pros?
I'm sorry?
Dismissed or null pros?
Null pros. I submit that the jury was never asked, nor did they, in fact, consider whether that occurred.
But I'm just curious. I don't know the answer. Is that any different than the Kilburn case? The jury was never asked to decide whether there was a second or a prior assault on the victim, and here the jury was never asked to decide whether Neves was assaulted. The effect of the null process is no different, it seems to me, than the effect that there was never an indictment to begin with.
Well, I think that makes it increases the concern that I have, because not having an indictment or not having an additional count means that the jury was never.
But there was no indictment for the other assault in Kilburn either.
But the Kilburn case relied upon the fact that the witness was unassailable, that what the witness said was uncontested. And I submit that in the Bell case, the case before the court, that And in Kilburn, the defendant never testified. In the case before the court, Bell testified. He created a contest, if you will, with respect to the Julie Nieves alleged assault, which then gave the jury or it might have given the jury some cause to address it, to find an independent ground to satisfy the predicate felony. Just like with the Julie Nieves allegation, there was allegations with respect to Julissa Cruz, and that too was no prost.
Was there evidence of 2 assaults on Julie Ann?
There was only one. There was only evidence of assault on Julie Ann in the bedroom.
Well, and Larry Keys and his testimony.
But, well, Larry Keys, that issue was never given to the jury to consider.
I understand that, but
Right.
there was testimony by him.
Yes, there was. But I will also say that again, Bell contested it by taking the witness stand and saying this never happened. Also, Larry Keys was a discredited witness. Larry Keys testified that he had been assaulted and battered, and the jury found Bell not guilty of that count. Keys also was the only witness who alleged an assault on Julissa Cruz, and that too was a no prost. Larry Keys was also.
But I just, by way of background, make sure I understand the facts. How did the defendant get into the apartment? Through a window?
The defendant entered the apartment through a window that he broke.
He broke the window.
What he testified to by accident. The prosecutor obviously asserted that it was willful.
Did he concede that he had a container with liquid fluid in it?
He did not concede that, no.
I'm not sure I see the defense of the accident.
I'm sorry?
I'm not sure I see the defense of accident.
Okay.
Didn't either the victim or the defendant throw the gasoline intentionally? I mean,
No, I'm sorry.
Didn't the victim, according to the defendant, throw the gasoline intentionally?
Yes.
Okay.
But that didn't start the fire. And I would say this, that Bell denied that he did it under oath, testified that he did not do it. His testimony was that Julianne threw it at him, but he
Intentionally.
that the gasoline was thrown intentionally. But I submit that the accident arises when the cigarette that Bell was smoking lit the gasoline. Now,
You have an intentional assault and battery on her part. The
Yes,
throwing of the gasoline.
but the application of a flame to the gasoline was never asserted by Bell. It was never made part of the defense. That, in other words, that Bell, his testimony and their whole defense was that it was just a horrible accident. That Julianne said, this shit is going to stop, and threw the gasoline. Now, I would submit that throwing gasoline without lighting it is a compelling deterrent to repel aggression by another. It doesn't take lighting the flame. I would also
What time did this occur again?
around 9:30 in the evening, sometime after 9. I'll finish with the questions about about accident. The point being is that the defense didn't assert that Julianne intentionally started the fire. No, I don't think it would take much convincing to establish that it's likely she didn't intend to start a fire. That created From that arises a question of whether the horrible affair was the result of accident. And the case law tells us that once evidence of accident arises, however slight, that it must be considered by the jury if it's requested. There's no question that it was not requested. But that gives rise to a different standard of relief or standard of proof or standard of review. But I would submit that under 278.33e that the question that I submitted, and I think in my brief I have raised it, that the defense attorney should have raised accident. He had his case there with him on accident. He should have asked for the instruction. The judge should not have taken accident away from the jury by his instructions.
The Commonwealth says that the word accident was never used during the trial. Is that accurate?
That is correct.
So,
But
the defendant testified to the fact that his cigarette lit the gasoline.
But the inference is clear that it was not something that he intended to do. And nor was there any evidence or ever any utterance of that it was Julianne's intention to start the fire, which leaves us, I submit, with an issue of accident. And that issue of accident was taken from the defendant.
But the only murder conviction he was found guilty of was felony murder.
Yes.
And if he did enter the home with a non-merged home invasion, it doesn't matter whether or not the death arose from an accident or not. He's still responsible for it.
I'm not sure I understood the question in terms of...
If a death occurs during the course of a home invasion, it's felony murder. He's responsible for it, even if it turns out that the police had come in and mistakenly shot somebody. He's still responsible for that death. So why does accident matter in a felony murder?
Well, I would answer that. Now I understand the question. Thank you. Is that typically accident in a felony murder case? There's no occasion to raise a defense of accident because the defendant never denies the commission of the predicate felony or bringing the weapon to the scene. Whereas, and I've cited examples in the brief where a robber enters a home and at gunpoint robs an occupant, and the occupant hits the gun, and the gun goes off by accident, killing the victim. Accident is not available because the malice of the robbery transfers to the homicide, creating malice, therefore felony murder, and the predicate felony is not denied by the defendant. In this case, Bell denied the armed home invasion. He denied bringing the weapon. So the predicate felony remained an issue. And along with the predicate felony remains the issue of accident.
Right, but I mean, are you saying that if the jury credited his testimony, that they would still have found him guilty because there was no accident instruction?
Guilty of,
I don't know,
Murder.
guilty of felony murder or guilty of home invasion? I mean,
I submit that the jury was not given the opportunity to consider that as a defense.
Consider as a defense. I mean, I guess, but my point is, is it your view that the jury could have thought that he went in to retrieve his keys and that the victim had gasoline and it accidentally was lit by the cigarette that he had either in his mouth or his hand, and the jury believed that but still found him guilty? Is that the concern we're supposed to have here?
Well, I'm saying that they weren't given the opportunity to consider accident as a defense to the element of armed home invasion, or to the element of arson, or to the element of felony murder.
All right. Well, moving back to going back to the merger doctrine.
Yes, Your Honor.
let's assume you are correct. Does he get a new trial? Does he get a judgment of acquittal of murder, or does he get a finding of felony murder by arson, second degree, because he was convicted of arson?
I think all of those are remedies. I think number one, I think I would like to preface my answer by saying, and I cited it in my brief, that Commonwealth versus Pagan is on point. And in Pagan, a defendant enters a home. There's multiple occupants. Two of the occupants flee to another room. One of the occupants is murdered by handgun or killed by handgun. Another occupant is placed in fear of death by the presence of the defendant and his staring at her with a gun in his hand. Pagan tells us that because the prosecutor never argued independent conduct to establish the predicate felony, that there were no jury instructions to give the jury a mandate to find an independent force to support the predicate felony, and that because of the fact that that leaves us with the likelihood that the jury used the force upon the homicide victim as the basis to establish the predicate felony. Therefore, the merger doctrine takes felony murder away. Pagan is on point because that's what happened in this case.
But unlike Pagan, you didn't have a deliberate premeditation to save you.
Well, right, because the jury was given the opportunity to find premeditated murder. They did not do that. They were also given the opportunity to find extreme cruelty or atrocity. They did not do that.
But in Kilburn, you have the court saying there was error, but there was overwhelming evidence that the jury found an independent basis. And of course, here we don't even need to struggle with whether there was overwhelming evidence. The jury found him guilty of arson.
But in Kilburn, the question was, well, first the court said that they're not going to weigh evidence on review. What they said was that because the prosecutor didn't argue independent basis for the predicate felony, because the jury weren't asked to consider it or mandated to consider it, they looked to whether the evidence of an independent felony was conclusively within the record. And on that basis, they said because this witness was not challenged by defense evidence, was not challenged by cross-examination, without reviewing the weight of his evidence, that it's clear that the evidence he provided was conclusive. I submit that Bell, the present case, is well aside from that, because in Bell we have a defendant who testifies this did not happen. We have 4 Commonwealth witnesses, none of whom were able to put the red gas can in the hand of Mr. Bell while in the house. Right. And yet, I'm sorry.
May I ask you, did any of them testify about the presence of the red gas can before this event?
They were unable to testify that there was the presence of a red gas can.
I mean, in fairness, they testified that he was holding something and squirting it. They're just not red.
That's correct. That's correct. And Mr. Bell said that he had with him Biotron, a silver-like container that he used to unplug a toilet. He was the handyman.
Could I just ask you, back to accident, one question? You said you thought accident was relevant to, in this case, to armed home invasion. I don't understand how the accident that your client testified to has anything to do with the armed home invasion. Is it because you say the only assault that could be part of it was the assault on Julianne?
I'm saying that if the jury, and I submit that the jury did use the assault on Julianne, or the force applied to Julianne, as the necessary element of armed home invasion, that if accident were given to the jury to consider, that they might not have found that force,
Okay.
which would then leave armed home invasion with an element short.
Mr. Hannafy, your time is up.
I thank you very much for your time, and I rest on my brief. Thank you very much.
May it please the court again, Catherine McMahon, Assistant District Attorney for the Hamden District for the Commonwealth. The defendant didn't try the case on a theory of accident, but nonetheless, the trial judge's jury charge made clear that the arson conviction was not accidental and the home invasion wasn't based on the defendant's accidental conduct. There were two stories here. One by the occupants of the home. The defendant broke a window, came in, chased people through the dining room, through the kitchen area to a back bedroom while he was strewing a liquid around, and by making threatening comments, I've got you, you think this is a joke, you think this is a game. Once they got themselves in, closed the door to the bedroom, he tried to force the bedroom door open. They then heard arguing and screaming, and then they came out of the room, saw the defendant leaving the house. His pants legs were on fire, and the victim, Julianne Neves, was in fire. The defendant said that he came there and made a phone call beforehand looking for his keys. No one answered the door. He tapped on a window. The window accidentally broke. He went in. He didn't see anyone at all in the home. When he got to the back of the room, he was smoking a cigarette. Julianne threw gasoline on him. The cigarette ignited the gasoline. She went on fire. And then he took the gasoline can and threw it, and the room caught fire. The jury obviously did not accept the defendant's story.
That may be so, but that's not what governs whether you give an instruction or not.
The trial judge, in instructing the jury on arson, said it couldn't be negligent or accidental. It had to be willful and malicious. So for the jury to find that the defendant was guilty of arson, the jury had to have found that the setting of the fire was willful and malicious, was not accidental, was not negligent, was not unintentional, but they rejected his version of events. As to the armed home invasion, when the judge was instructing the jury on the element of knowing that other people were in the home, he said that that can't be unintentional or accidental. So that it's clear that the jury rejected the defendant's version of events based on adequate instructions, and that the jury did not find that this fire was caused by the defendant's cigarette accidentally igniting gasoline that Julianne threw at him. The jury found that the defendant set fire to Julianne and the home.
So what was the armed home invasion conviction, which was the underlying felony of the felony murder conviction?
Right.
What was that?
Okay, the defendant broke into the home carrying some kind of a container that had the gasoline.
Yep.
He also had one or two knives on his person. Larry Keyes saw one knife in his...
What was the assault in the home?
He chased Julissa from the dining room into the kitchen. The other members of the family had been in the back of the house.
But you know Prost that, right?
You didn't pursue that.
But we presented evidence of that.
But what does that mean? I mean, I don't, it's the first time I've ever heard of the Commonwealth pursuing evidence and presenting evidence and relying on evidence, but not crossing the count?
3 counts were not pressed. If those counts had not been not pressed and the jury came back with verdicts of guilty, then we wouldn't be here today at all on these issues.
If they came back with verdicts of not guilty.
If they came back with verdicts of not guilty, that would be a different story. But
I assume that's what you're worried about in not crossing them and not presenting to the jury.
No, I think in terms of the assault with a hammer on Julissa was not pressed because the trial prosecutor was concerned that she had some special needs and he was concerned about her ability to testify. That's why that was not pressed. He didn't put a reason on the record for why he not pressed the knife attacks on Julianne and Tiffany. Julianne was deceased, but Tiffany testified.
What is your theory? The independent felony was the other assault on Julissa when he chased her from the dining room to the kitchen?
There was chasing Julissa from the dining room to the kitchen. There was chasing the rest of the family from the kitchen area to the back bedroom while
Okay.
throwing gasoline and making threatening remarks to them. And there's making slashing gestures with a sharp object at two of the people in the home.
But then are you asking us then to reverse Kilbourne, which says that the evidence must be overwhelming when there's error of the judge in failing to instruct the jury that they are to identify or is to set forward what the independent felony is?
I'm saying that this is like Gunter and this is like Kilbourne. Kilbourne is one victim with two different blows.
But the difference is that Gunter suggests that it's merely the sufficiency of the evidence that we look at. Kilbourne says, no, it must be harmless beyond a reasonable doubt, and it's only harmless beyond a reasonable doubt if the evidence of the independent felony is overwhelming.
I would submit that here, where the jury rejected the other version of events and the other occupants in the home testified that the defendant had chased them through the home.
So, but you're saying that where the jury found the defendant not guilty, or where you null prost it with regard to those assaults, we should still find the evidence to be overwhelming?
The underlying felony for felony murder doesn't even have to be charged. And it can still be sufficient, it can still be overwhelming. So the fact that the jury isn't asked to like render like a verdict slip on the underlying charge.
Nobody's disagreeing with that, but Justice Gants, I think, is asking you, what is the overwhelming evidence that exists here? Did each of the family members testify that they were chased to the back bedroom
Yes.
while being threatened?
Yes.
So how many family members were there?
There was the aunt, there was Larry, there was Tiffany. Julissa did not testify. The son of the victim testified.
Okay, so the aunt, there's nothing to show she was disbelieved, is it? Well, who were the
Larry
who
Keyes.
did the null process? Larry Keyes, there was the not guilty, but there were null process as to Julissa and who else?
Julianne.
And Julianne. So you're saying that Tiffany and the aunt and the son all testified to being chased to the back bedroom
Being
during
chased
threat.
with the gasoline
And
being
that
thrown.
their overwhelming testimony, their testimony is overwhelming despite the not guilty verdict for Larry. and the
Because
null process.
Larry said he had been splashed with gasoline in his face. The laboratory analysis of his clothing showed no gasoline on it. The jury came back not guilty on that. They have been questioned as to whether the gasoline was thrown by the defendant at them, and only Larry said that it was thrown at him. The other people testified that it was thrown around, which is still a menacing thing to be spewing gasoline all around someone's home while chasing them and threatening them. Larry is the person who saw the defendant wielding a sharp object make slashing gestures towards Tiffany and Julianne. No one else testified to that. But there were two stories, that he broke in, that he chased them, spewing gasoline, threatening them, trying to force his way into the bedroom. And
Did they all testify about the statements he made?
the statements weren't exact, like, what, you think this is a joke? I've got you now. You think this is a game? Those are the comments he was making after being angry on the phone because his girlfriend wouldn't come to the phone to talk to him. That was what preceded the entry into the home.
So give me a better sense of what the judge instructed the jury, what the judge told the jury they needed to do in determining whether the defendant was guilty of felony murder. How did he describe the underlying felony? That
He gave a definition of armed home invasion, which did not say that the acts for the assaultive acts for the underlying home invasion had to be separate and distinct from the acts which caused the victim's death. He did not say that. It was not requested by either party.
So that was error.
Yes.
And
Well,
I mean, doesn't it come down to that you're basically asking us to find that the error was harmless beyond a reasonable doubt because of overwhelming evidence as to an assault for which the jury either found him not guilty or you null prost it?
Well, is it the harmless standard when it's unpreserved, or is it substantial likelihood? I think Kilburn applied the substantial likelihood test. And here it wasn't requested, it wasn't objected to, and we've got
But of course, the problem is we don't know what the jury did. So
Well,
we
I think-
basically have to say that if the instruction were given correctly, we are certain that the jury would indeed have found that there was an unmerged assault here. And I don't see how we can do that when the jury, as to the assault crimes, found them not guilty, or you chose not even to prosecute them. That's the fundamental problem.
Well, the separate assaults weren't charged in Gunter either.
But is there, your answer is obviously no, but there's something that seems a little different when there is nothing charged, but there's evidence. I mean, it's true in Kilbourne as well. And when you've got a whole bunch of charges that the prosecution then, for one reason or another, doesn't go forward with. Or you get a not guilty.
The not guilty is something where you know that the jury rejected something because they rendered a verdict. The others we don't know because they weren't asked to pass upon those specifically.
Right, but we would have to say we are certain the jury would have convicted on those 2 counts that the prosecution chose, for whatever reason, not even to pursue after having indicted. I mean, that's what you're asking us to do, isn't it?
Not necessarily. The slash with the knife, or isn't it not a threat to chase people, all those people through their home, making the threatening remarks and throwing the gasoline around, chasing them all the way to a back bedroom, where there's 2 sides on that point. Everybody says the defendant chased them while making threatening remarks after breaking the window to come in and throwing the gasoline around. And they only escape him by getting into a bedroom door that they close and that he can't open. The defendant's story is he was simply walking through a dark house with nobody there when he is attacked. So the jury absolutely rejected that. I think the arson verdict shows that they absolutely rejected that. And here, you've got one side of the story is that he attacked all of them, chasing them through the house, throwing the gasoline all the way to the back bedroom. And apart from whether there's a not guilty on the gasoline to Larry's face, or a nolle pros as to the slashes with the knife, or a nolle pros as to there was absolutely no testimony of an attack with a hammer. That was the indictment where Julissa was the victim. But apart from those, the attack of the whole family through the home with the gasoline would be sufficient to support the armed home invasion as the underlying felony, and it's separate and distinct from Julianne. She had an encounter with a defendant at the back of the house after that chase, where she didn't make it into the bedroom. They heard an argument, the other people heard an argument and screaming, and then she was engulfed in flames when they opened the door. So on that basis, you can sustain the verdict of first degree based on felony murder. If you can't, the jury was not instructed on second degree murder as malice murder, but the jury was instructed on arson. And so, the jury never passed on the question of felony murder, arson. It was only felony murder in the first degree that the jury was asked to consider. But I think under 33E, you're not limited necessarily to what the jury was asked to pass upon if there's enough in the record.
So I take it what you're saying is if we should conclude that on the basis of the way this case was tried, the armed home invasion merged with the murder. If we conclude that, we can still find second-degree felony murder based on a death occurring during the arson.
Yes.
All right.
And unless you have further questions, I'll rest.
Thank you.
Thank you.
Thank you.